Hello, welcome to Rappler Talk. I'm Marites Vitug, and joining us today is the counsel of the Vice President, Leni Robredo, in the sedition charges or a case filed by the Philippine National Police. Just to give you a context, September 23, yesterday, was the day President Marcos announced or addressed the nation about declaring martial law 47 years ago. So this is timely as we talk about a case that reminds us of a time when dissent was stifled. And Marlon Manuel here, a young lawyer. Were you already a lawyer during martial law
No,
years?
of course not.
Okay.
I was born during martial law.
Oh my God, he's a martial law baby.
I'm a martial law baby.
But now he's the lawyer of the highest-ranking official charged in a sedition case by the Philippine National Police. So welcome to Rappler Talk, Marlon. Thank you for joining us.
Thank you also for having me.
Yeah, just to review, September 6 was the day that the panel from the DOJ concluded its preliminary investigation on the sedition case,
That's right. That is the last hearing date
Correct.
of the preliminary investigation.
Yes. So now they will have to resolve it, submit it to the DOJ. What are the steps? Can you walk us through?
Well, it's a panel that
Yes.
was constituted specifically for this case. So the decision of the panel will be to either to file the case,
Correct.
if they find probable cause, or to dismiss the complaint.
But they will recommend this. They are recommendatory, right? So the Secretary of Justice who will make the final decision.
The panel should be able to have the decision on as a panel of prosecutors.
So, and you were saying earlier in our conversation that you expect the results to be out by November.
Before the end of the year, we're expecting the results. Since September 6 was the last hearing date, so we expect to hear from the panel to have the decision before the end of the year.
Are you optimistic or pessimistic? Optimistic that that these charges will be dropped.
As far as VP
Vice
Leni, as far as the Vice
President,
President is concerned, we are optimistic that the case will be dismissed. Based on the complaint and the sinumpaang salaysay of Bicoy, which is the sole basis for the complaint, there is no reason to prosecute the Vice President.
Yes, in the counter affidavit of the Vice President, it was very clearly stated that Peter Jomel or Bicoy told a lie. There was no such meeting between him and the Vice President. So, will you file a perjury case, or is this out of the question?
Well, the filing of a perjury case is always an option. But right now, the priority is to have the case dismissed. We will discuss the perjury case later.
So, you're not doing anything yet until you hear from the
Well,
panel?
we have not filed a counter complaint. Some of the respondents filed a counter complaint. We did not, but we still have that option to file a separate case for perjury at a later date.
Okay. Now, what's intriguing is that this is a complete lie. So
Definitely.
yeah. So
And,
no,
and that's the only allegation in the complaint, or in the sinumpaang salaysay. There is no other alleged act of the Vice President aside from that supposed meeting.
yes, on a certain date wherein the
On a
Vice
certain date
yeah.
at an exact time.
And the Vice President clearly showed that she was in Bulacan.
He was not in Metro Manila. He
That's
was in two places in Bulacan, in Bukawe, and in Bustos
Yes.
on
Have
that
you
day.
ever encountered a case like this where it's based on a complete lie? I mean, you're a young lawyer, but you've had experience as head of the alternative law groups. You've been, defending.
Well, not to this magnitude. When you have filed a case against 35 individuals, including the
38,
second,
including the John
well,
Does?
including the unidentified
Okay.
respondents, and including the second highest elected official, based on the brazen lies in the sinumpaang salaysay. So this is unprecedented.
Unprecedented. So what is the agenda here? I read the counter affidavit, and it also says that this is a political case. So this is a case of persecution. What's wrong with the Vice President?
Well, we have to look at the context
Okay.
of the case. This is not an ordinary complaint filed by a private individual against another private individual. This is a case initiated by the CIDG under the Philippine National Police, supported by the Office of the Solicitor General, not only against the Vice President, but against key leaders of the opposition, including leaders of the Catholic Church. So this is clearly political. There's a clear political agenda to harass the Vice President, to persecute known opposition leaders, those who are vocal against certain policies of the current administration. So that is certainly political.
And do you think that there is recourse other than, I mean, what is the recourse if lawyers are faced with this, as you were saying,
Well,
unprecedented?
We have to go through the process. This is a preliminary investigation. That's why we have filed a counter affidavit exposing the lies in the Sinumpaang Salaysay, which is the only basis for the complaint filed by CIDG. And we are expecting the DOJ panel to do its job of looking at the evidence presented. And as far as the Vice President is concerned, insofar as the charges stated in the complaint are concerned, there is clearly no basis to file an action in court.
And the counter affidavit of Vice President Robredo also argues that if the testimony or affidavit is, the testimony rather of Bicoy is false in one, it's false in all. Does this really hold in jurisprudence?
It's a principle in looking at evidence, in looking at allegations. Because some of the allegations are interconnected, or most of the allegations are interconnected. So it's like a puzzle. If you cannot complete the puzzle, then you do not have a complete story. And Bicoy's story is based on different elements, including the supposed participation of Vice President, and especially that supposed meeting, which never happened. So if you destroy that allegation alone, that means the whole story collapses. There is no basis to rely on, because this is a story based on a number of different elements.
But as we know, this is not a normal time. I think you were saying the context, there's a bigger context to this. And in fact, the Solicitor General is actively participating.
Yes, very active.
But you wasn't this questioned earlier that why is the Solicitor General, why did they help in the drafting of the affidavit?
Well, you will recall that initially there was a denial of the role of the Solicitor General. And then eventually, it was discovered that indeed the complaint filed by CIDG and the Sinumpaang Salaysay went through the Office of the Solicitor General, reviewed by the Office of the Solicitor General. And at that time, there was an admission that indeed the Solicitor General's office supported the CIDG as the client, as a government agency. And then during the hearing itself, during the first hearing, an officer of the Office of the Solicitor General appeared as counsel for CIDG. So it was clearly an active participation on the part of the Office of the Solicitor General. That was questioned during that hearing, and formal pleadings were filed by some of the respondents questioning the role of the Office of the Solicitor General, but the panel decided that the preliminary investigation is not the proper venue for resolving that issue.
But what is wrong with the Solicitor General actively participating in this?
Well, there are legal issues that had been raised by some of the respondents, including the role of the Office of the Solicitor General as an appellate counsel, meaning on appeal, not at the level of the preliminary investigation. But I will not go into that. I will not go into the legalities. Let us just look at the propriety of the action of the Office of the Solicitor General, supporting a complaint based on the Sinumpaang Salaysay of Bicoy and filing a case against the Vice President, among others. So you see the Office of the Solicitor General is prosecuting the second highest elected official. So the Office of the Solicitor General is not going after criminals, not going after syndicates. The Office of the Solicitor General is prosecuting the Vice President of the Philippines.
This is again unprecedented. Right?
Again, this is unprecedented. Of course, their excuse is that they have CIDG as their client, and as counsel for the government, they can act as counsel for any government agency. But again, let us look at the bigger context. They are pursuing the Vice President of the Philippines. So why will you use the resources of the Office of the Solicitor General to file a case against the Vice President, especially when you know, looking at the sinumpaang salaysay, that there is clearly no basis for the complaint?
I thought the Vice President is immune from suit. Isn't there a provision?
It's not really a provision. We are just looking at the impeachment provision of the Constitution and saying that for not only for the Vice President, but for those who are impeachable, if there is any action that can be filed, that will be filed against them, which may mean termination from office or disqualification from public office, then that is not allowed, supposedly, because these officials are impeachable. So it's different from the immunity. It's different from the immunity from suit. It has to do with the category of certain officials of the government who are impeachable.
So that includes the Vice President.
The Vice President is an
Yes.
impeachable position.
In the past, have Vice Presidents been, prosecuted? This is unprecedented, but
As far as I know,
Yeah.
this has not been done before. Not a sedition case against the Vice President, not the Office of the Solicitor General pursuing the case. This is the first time. This is the first time.
And of course, even if you're a martial law baby, you know what happened during martial law. And it was different then.
Of course,
yeah.
different circumstances. That was an emergency situation. Whether it is a factual emergency situation or a contrived emergency situation, still that was made the justification for martial law. So the powers of the government, the nature of the exercise of the powers under martial law would be different compared to our situation now.
Now, there is no martial law. It's only in Mindanao. Yet, we're experiencing this. I mean, like, especially the level of the Vice President. As many people have called this the weaponization of the law. Did you experience, in your readings, when you teach law, has this happened also during the martial law years?
Oh yes. In fact, Senator Benigno Aquino, Senator Ninoy Aquino, was, as you know, imprisoned together with many other opposition leaders, Senator Jokno and a few others, because of the Marcos's accusation that they were conniving with the Communist Party of the Philippines. So as far as that is concerned, that there had been historical experiences in the past that the law had been used, the justice system had been used to go after the key opposition leaders.
And so what does, but again, earlier we were talking about, yesterday rather, when you spoke at the launch of the Concerned Lawyers for Civil Liberties, which is a relaunch.
It's a relaunch
of a movement founded in 2005.
2005, 2006.
And you are one of the conveners, and I want to relate this to what's happening now.
And that was more than a decade ago. And we are relaunching it.
Correct. So it was founded during the time of President Arroyo because of certain conditions which were cited, like she declared an emergency rule,
Yes,
right?
there was a Proclamation 1017, placing the Philippines under a state of emergency. There was an executive order 464, Executive Order 464, prohibiting cabinet officials and other key government officials from appearing before inquiries in aid of legislation.
Oh, yes.
Before Senate,
yeah.
House investigation. So all of these were attempts of the government at that time under President Arroyo to repress the truth, to stifle dissent, whether opposition or civil society groups.
So that was 2005.
2005.
Then 2006, I was really amazed I forgot all about the historic March of Lawyers in 2006.
2006, yeah.
Now, can this happen again under these circumstances, under Duterte's rule?
If necessary, then lawyers will march again.
But your conservative lot, you lawyers.
Well, lawyers, members of the legal profession, the justice sector in particular, are conservative. And that is why when lawyers come out, and when you see lawyers marching on the streets, like what happened recently in Hong Kong,
Yes.
in other places, then this is something unusual. Something must be terribly wrong for lawyers who are usually non-political, not public in their statements to come out as a group denouncing certain acts of the government.
So, let's go back. 2005, 2006, the conditions were ripe. You formed CLCL, Concerned Lawyers for Civil Liberties. Now it's being revived 2019. But I think there are differences between 2019 and 2005. So maybe you can walk us through this. Maybe how will you navigate this new environment?
Well, if we look at the situation in 2005 and 2006, there are a number of similarities. But one clear distinction was that President Arroyo at that time was in a survival mode. She was trying to preserve her hold on to power. There was the Hello Garci controversy, questioning the legitimacy of the presidency of her position. So we don't have that now. So we have there is no question about the legitimacy of the president. So that is something different. And of course, compared to in terms of popularity, we can see that public perception is still in favor of President Duterte now, compared to President Gloria at that time, who was very unpopular in 2005 and 2006, and in the succeeding years as well. There are a number of developments that had changed politically. We are more divided now as a country compared to 2005, 2006. So there are complexities that make the situation now different from the Gloria Arroyo situation in 2005 and 2006. There was a rise in extrajudicial killings at the time, also today, but again under different circumstances. At that time, there was the push against the rebellion, the communist, the armed rebellion of the New People's Army. But now it's a different war. It's the so-called war against drugs. So similarities, there are plenty of similarities, but I would say the situation now is more difficult to navigate.
But what do you see will be the impact of this sedition case, because they're targeting the second highest official of the land? Do you think it will have an impact on public opinion, or are people just not listening or watching these developments?
I think people are starting to realize that this case filed against the vice president, against bishops, against all the candidates of the opposition, except for one, is clearly an attempt to charge those who are outspoken about the current administration, outspoken about the policies of the current administration. I hope the DOJ panel will also see through that reality, that agenda, in the filing of the sinumpaang salaysay and the complaint filed by CIDG.
Yes. On September 6, the DOJ panel said that they were not going to accept any evidence, right?
That's right.
So the case rests on the testimony of Bicoy.
That's right. Even before September 6, during the first hearing, remember we filed, the vice president and other respondents filed motions asking the complainant CIDG to produce all pieces of evidence that they were referring to. Because in their letter complaint, they mentioned other evidence to be presented later. So we were asking, you have to present your evidence now. So that when we file our counter affidavits, then we will see all the items of evidence that you have. And then, during the first hearing in August, the Solicitor General's representative said they are no longer filing any additional document. They are no longer submitting any other evidence aside from their undertaking that they will give all the respondents a copy of the USB that they submitted to the DOJ panel. So, in fact, we clarified during the hearing so that the only additional evidence that we will be getting as respondents would be the USB copy.
Which contains
what we already have online.
the video,
the series.
Yeah.
The series.
The Totoong Narcolis.
The Totoong Narcolis series.
Okay.
So there's nothing pointing to the alleged sedition. In that, it's just the series. That's the content. That is what is contained in the USB. So the only evidence of the complainant, the complaint is a referral letter. It's a complaint letter from CIDG. And the only attachment, the only document submitted is the sinumpaang salaysay of Bicoy, together with annexes, including that USB. So that will be the basis of the complaint. That will be the only basis for the DOJ panel to determine whether there is probable cause to file a case for sedition against the Vice President and the 30-plus other respondents. In fact, if you look at it, for the Vice President's case, there's only one paragraph. It's not even the entire sinumpaang salaysay. It's just that one paragraph which mentioned that supposed meeting which never happened.
Yes. And as you were saying also before, and other lawyers have said, the 30-plus respondents, their crimes, their offenses were not specified, right?
That's right.
So it's
There are seven. There's 7 separate offenses, including estafa.
Who committed estafa?
It's not mentioned in the sinumpaang salaysay or in the complaint. So it's really a lumping together of 30-plus people, respondents, and lumping together of 7 offenses without specifying who did what, who committed which offense. There's even a complaint for obstruction of justice, for harboring a fugitive, and that's Bicoy.
So it's the DOJ panel's job now to sort out who committed what. Isn't that part of their job?
Well,
or it shouldn't be the CIDG?
Usually, when you file a complaint affidavit, you're specifying the crime that you are accusing the respondent to have committed.
Correct.
That's the usual complaint affidavit. This is unusual because you have 30-plus respondents, you have 7 offenses, and you have a narration, a very long narration of facts. But the DOJ panel will have the final say. Whether you have, even if the complaint affidavit had identified just one offense, for example, that is not final. The prosecutor in the preliminary investigation will determine the proper offense. So same here, and especially in this case, when you have several offenses included in the complaint and several respondents.
So this is a case of which has many unusual facets.
Definitely. Bicoy himself is an unusual personality, and that became the basis for the complaint of CIDG.
You're the counsel of the Vice President. So what does she feel about this case? I mean, is she worried? Is there some unease? Or
Well, the Vice President is a lawyer herself.
Right.
So she understands the process that the case should go through. Having said that, she's also cautious because she also knows that even with our system in place, even with processes, and as experience would show us, these processes are sometimes sometimes used or abused for political purposes. So I wouldn't say she's worried. She continues with her work. She continues with her advocacy, but she's also cautiously awaiting the resolution of this
Yeah.
case.
Because apart from this sedition case, there's also the Supreme Court election protest case, but that's a different
That's a different
thing.
thing.
Yeah. Yeah, but you're not the lawyer there,
I'm
right?
not I'm not the counsel for that case.
Yeah, so some of the respondents went to the Court of Appeals. I think that's FLAG, Free Legal Assistance Group, and Alejano, and maybe one more respondent. And they questioned the legitimacy of the panel, right?
That's right.
And how will that affect the DOJ panel, which is still concluding its...
Well, as long as there is no restraining order from the Court of Appeals, then the panel will continue with its work. And until now, as far as I know, there is no restraining order issued by the Court of Appeals in any of those cases. So it is safe to assume that unless we hear from the Court of Appeals anytime soon, then the DOJ will continue with the DOJ panel will continue with the resolution of the case.
Yeah. So maybe just to sum it up or wrap it up, again, in your not so long experience as a lawyer, you have worked in alternative law groups, you've been teaching law, you've been defending marginalized sectors and labor, the labor sector. How would you compare the state of the rule of law in this country compared with in the past years, past administrations?
Unfortunately, we're seeing a regression in terms of the credibility, public perception about the justice system, which is unfortunate because we have also helped improve the credibility of the justice system, even the Philippine National Police, for example. But now all of these institutions are affected by what's happening.
And how does it affect your work as a lawyer?
Lawyers will continue to do their work, continue with their advocacy, regardless of whether you have a working justice system. Like what happened in martial law. You continue to file cases, you continue to litigate cases, even if you know that the institutions that will eventually decide the case will be deciding the cases in favor of certain political interests. That happened during martial law. And we have seen many cases filed. We have seen, for example, the late Chief Justice Tihanki, who was always a dissenter in many decisions of the Supreme Court. So lawyers should continue.
On that encouraging note, we will conclude the interview, and thank you so much, Marlon.
Thank you.
We'd like to just remind our viewers and maybe listeners that let's keep watching what's going to happen to this sedition case filed by the Philippine National Police against 38, right? Or maybe 35 known opposition figures led by the Vice President of the Philippines. So this is unprecedented, as Marlon has said, and a lot of unusual steps were taken to push this case. So let's keep watching, and we'll update you in future Rappler Talk interviews. Thank you and good day.
Salamat.